Hey everyone, today's conversation is a guest we've had on before. We were lucky to have her before. We're very lucky to have her on again today. The conversation is going to be about influencer marketing. It may be about trademarking and when have you gone too far with free speech, or are you not going far enough? And we might, depending on how things go, we may end up talking about food advertising law, which is fascinating all by itself as well. So if you care about life sciences, if you care about conversations associated with should I use an influencer in my ads, you probably care about today's conversations. Our guest today is the Frank Stanton Professor of First Amendment Law at Harvard Law School. She's been a guest on this interview before, and we're lucky to have her again. This is Darshan Talks live stream. I'm your host, Darshan Kulkarni. We're both attorneys. Neither one of us are giving you legal advice. I'm a pharmacist. I'm not giving you clinical advice. These are just conversations we're having. They do not represent the opinions of ourselves. Well, they might represent our opinions, but they don't necessarily represent our opinions of ourselves, our guests, our hosts, our employers, or our clients. I should also say, if you want to, we'd love to hear from you. So if you'd like, leave a comment, please subscribe, please share, please ask our guest questions as well. You can always find me on Twitter, Darshan Talks. Go to my website at darshantalks.com. You can actually find Rebecca at Tushnet on Twitter, or you can go to her blog, tushnet.blogspot.com, where she posts quite frequently. So I'm really excited. Thank you again for coming on. Our guest for today, Rebecca Tushnet. Hey, Rebecca.
Hi, thank you for having me.
Thank you for coming on. So let's start from the beginning. You posted very recently about this case on influencer marketing and what that looks like. There's been some updates. Can you tell us a little bit about it?
So regulatory attention for a while has been directed at influencers, in part because what we got with the rise of the influencer economy is just a wave of people who weren't advertising before and now are, and so have to be brought into the system, but don't necessarily know the rules and didn't come up through like an ad agency or through a business where they would be socialized through ordinary business processes. So that has contributed to a certain Wild West flavor, as well as substantial interest by regulators in actually coming in and sort of substituting for the instruction that you would have gotten from an ad agency or a traditional employer. So it is not a rule-free space, but it is not surprising that we see a bunch of people behaving like it is, and so regulators are, I think, particularly hot to trot. And also, there are opportunities for using influencers in ways that are deceptive. And that means that private entities, competitors, may also end up challenging somebody's use of influencers.
So let's talk a little bit. Let's break it down, first of all. What is the difference between an influencer and a spokesperson? Is there an actual legal difference?
So there may not be. So in particular, the FTC strongly takes the position that if you're paying someone to promote a message, then you're responsible for that message, even if you give them control over the details of it. And in fact, that you have given them details, control of the detailed message may actually mean you assume the risk of having them say something that you can't substantiate. And particularly in the area of health and safety claims, the regulators are very unhappy when you basically don't put your spokespeople or your influencers on a leash. It's interesting because ordinarily you're just responsible for what they say, and you don't get one free bite. But in recognition of some of the unique challenges of influencer marketing, regulators have generally said, look, if somebody says something that they're not supposed to, you got to cut them loose like that. So there is that little bit of gap that, that since it wasn't a script, if they go off of what you can substantiate, you do have to respond to that and tell them, go and sin no more. Or get rid of them. So there is that little bit of flexibility, but largely you do have to be monitoring, especially because you've handed over a bunch of control of what message actually gets out.
Which is actually very consistent with what the FDA expects as well. So you talk about the FTC. Obviously, the FDA has similar thought processes. But I've always thought of spokespeople as really, I mean, you sign the contract, there's much bigger numbers at play, and therefore I assume that in most industries they get more training, and there's really speaking in a very controlled environment, as opposed to what I think of with influencers, which is you go out and preach the gospel, if you will, of my amazing product, whatever it is. Um, do you? I mean, from a legal perspective, obviously, there is this. Well, they're all the same thing, and they're agents, if you will. But at a practical level, it's really impractical to control that. And at what level, at what point are you controlling? Is a free gift to someone who is an advocate for your product
Right.
still a making them an agent, or do you need to have a contract in place?
Right. And the answer that the regulators have tended to give is a formal contract is not required if the if consumers would need to understand that you got the product for free in order to understand the weight of your opinion, then you have to disclose it. Of course, that's purely about the relationship, right? So that's the thing that could be deceptive to consumers, is if they think it's a completely unbiased opinion, versus if you disclose, I got this for free, then consumers can understand, take it with a grain of salt. Although interestingly, the research suggests that that kind of disclosure might not quite be enough, because consumers might not fully understand how likely it is that getting a free sample or free gift biases the evaluation. Like they just might not adjust correctly. But in terms of just purely whether there's a relationship, the FTC says, look, if consumers care about whether you got a free sample, you have to tell them you got a free sample.
So you talk about adjust correctly. How do you determine if something's been quote unquote adjusted correctly?
In terms of okay, so the FTC thinks it's basically in some sense it's case by case, right? So in fact, I think it's an interesting question. Does Kim Kardashian need to disclose, or are her followers so attuned to the fact that she doesn't do anything for under $100,000, like which is one estimate of, she charges six figures for a post. So if everybody knows that, actually additional disclosure is not necessary. But if people wouldn't understand that, so for perhaps someone who isn't a worldwide celebrity, then you do have to disclose that there's a relationship, including just that they send you free stuff.
So it's funny you mentioned Kim Kardashian, because she's one of the what the FDA had a very big case with her.
Right.
OPDP put out something on her.
Right.
So I find what I find interesting though is the way she probably was. She did a sponsored post, is what I would imagine is what it was. She was not in any way necessarily a spokesperson. So I guess when I think of a spokesperson, I think of someone, for example, sharing Omega watches. So you're going to be wearing that watch for the next year and a half. Sending out a single post, did that make her an agent by definition? And how long does that agency last? Is it purely for the one transaction or multiple going forward?
Right. In terms of whether it's going to be attributed to the pharma company, so I think the agencies all answer yes. Right. There was an agreement that you would promote the product. Right. You promoted the product. And so it's interesting for Kardashian, of course, the issue was not that she didn't disclose that there was a relationship. I mean, she didn't do a great job, but it certainly there were some loosey-goosey words, my partners, whatever. That's not the recommended method, but for Kim Kardashian, you probably know it. But her problem was substantive. She said a bunch of stuff that, doesn't match the label.
Right.
And she didn't disclose a bunch of stuff that has to be disclosed if you're doing regular advertising. And the FDA's position on this is completely consistent with other regulators, right? You can't arbitrage new forms of advertising to get out of the restrictions that apply. So, given that money went from the pharmaco to her to post this message, they are responsible for the content thereof. The big difference that is actually a loosening is essentially this idea that as long as they rein her in after the fact, then they won't be held liable for the initial violation. And she ends up posting this 3-screen big clarification of what should have been in the ad in the first place.
Which to me, honestly, was almost a bit of a cheat, because she went essentially the pharma company got two for the price of one, in that they got the actual initial ad, which had, I think, something like 14 million engagements, and then they had the second one, which is all FDA cites it as being problematic, so all the news agencies cover it, and
Right.
then they put out a third piece, which is, here's how we should have done it in the first place. And my question to you is that seen in any way by the agencies to be intentional, or is it just too hard a case to prove at that point?
So that's a great question, and I think part of it is likely some leeway for the the first people to fall afoul of this. Um, I one interesting question. I actually don't know. Did they pay her more to
I
because
wondered.
to the extent it's an arm's length contract, like they may actually have had to pony up more to get that correction. I don't know. I doubt that anybody outside the relationship knows. But this is my take on this is, look, you you wanted the benefits of this informal, right? Like personalized, it feels intimate, right? It feels more authentic. If you want those benefits, you take the risks that come with that, which includes the risk that the person is going to go off script and you're going to be held responsible for that.
So what would have happened if she would have come back and gone, this is too much, I don't want to be part of this, I'm not putting out a corrective ad, you guys are on your own? Does the pharma company still retain the problem, if you will, and try to
So
fix it?
that's a great question. And so the FTC has basically mostly assumed that the relationship will continue. I think it would be an acceptable answer to say, okay, she screwed up. Our relationship is now terminated. I think the pharmaco would still need to, put out its own like press release, like this is the full information. Be relatively easy to do that. But from the way that the agencies have treated influencers so far, if you did a public breakup, that would probably satisfy your obligation.
So if that's true, can we is there such a thing as a halo effect in the context of influencer advertising? And what I'm referring to is, I'm visualizing a scenario where at one point I think Paula Deen was a spokesperson for something, and she made delicious food. And then she went down and was pushing some kind of diabetes med. I really don't remember which one. My question is there a halo effect where it goes, as Paula Deen, she can cook delicious food and still not be affected by the ravages of diabetes? Isn't that wonderful? And therefore, this drug has more. Does influencer advertising cause that, or does it have any special impact, or is that sort of, I'm making this up?
So, I think the answer is, we think it has an impact, but also this is just very much like, I don't know, culturally dependent. So there's I think people rushed into influencer advertising because the consumers are saying, well, these people feel more authentic to me. But, will that still be true in 10 years? Right. Or will we all be on to like metaverse avatars? And I think the only thing we can really predict is that advertising will evolve, and stuff that seems authentic to us today will not seem authentic to us, 20 years from now, just as, 20-year-old ads just don't look very persuasive to us. And it's not because people 20 years ago were dumber. It's that the culture moves in terms of what even is credible and authentic, right? So, in the 60s, all the ads were doctors wearing white coats. And that would no longer work in many situations.
Which really raises the question of what happened, probably, I think it was at this point, probably about 10 years ago, with Juul, where Juul was advertising its products using influencer marketing with I don't know if there were kids actually in that case, but young looking people pushing it, and kids started using it. Are there special responsibilities that you'd have in the case of a product like a nicotine replacement therapy?
So it's a great question, and certainly anything that suggests that you're actually marketing it for an unlawful use, like a use in kids, would be a very serious problem. And part of this, of course, is especially new products are particularly likely to use new channels where the regulators haven't quite got their hands around the channel yet. So I, I don't think the standard is any different, but I think your ability to evade it differs.
So we're talking about this idea that you have the ability to evade it. What are you seeing as the newest challenges, newest areas that people like? You mentioned metaverse a few seconds ago. Is that the new frontier? And do you tell people when you I assume you don't advise people anymore, but I always think of the Fox v FCC decision where the courts basically came out for those people who don't know and said, if you don't define what's prohibited, you don't get to prohibit after the fact. Essentially, you got to be specific. So if that's true, um, should lawyers who are considering advising clients tell people don't get into scenarios where we don't know the rules, or is it better to actually work in those open spaces because the rules just aren't clear?
Yeah, so part of this is, of course, a matter for our clients' risk tolerance.
Yeah.
But I actually don't think it's fair to say that the key rules here are unknown. I mean, their application may sometimes be hard, but actually, the FTC has been super clear, and it was before the rise of the internet that if somebody is actually paid to speak for you, right, and consumers would care about knowing that, then you have to disclose. So some of the really interesting precedents come from I think the late 90s when security companies pay people to go on like Good Morning America and talk about how good it is to have a home security system. And that's actually deceptive because most of the people on GMA, either you understand like they're here to promote their movie, or they actually aren't paid to come and talk about their issue. They're paid by their interest group to talk about their issue, right? As opposed to like you present someone as an independent security consultant, and they're actually touting a particular provider's home defense system. So and likewise the sort of substance of it. So don't say things that you can't substantiate. Don't make factual claims you can't substantiate, although that's that obviously needs very specific application. It's you can understand by looking at what you've agreed that the influencer will say whether these are things that require substantiation. So I would say it's actually not it was a bit the Wild West in the sense that there were lots of new people who didn't know that there were rules, but there always were rules. And now the regulators are really, aware that this is a space. And so I don't think the advising would be any different, except for the sort of practical human relations part, right? That these are a different kind of independent contractor than you're used to working with. And so, there are predictable things, although there's a real estate lawyer who wrote this great thing about salespeople in general. So look, salespeople, they're like toddlers around pools. You cannot leave them unattended or tragedy is going to result.
That is so terrible. I have so many sales friends, and I'm having a hard time saying that to them. But that sounds hilarious. So let's talk a little bit. We talked about these influencers at a global level. We talked about Kim Kardashian, if you will, and then we but what happens if those influencers are local? And what happens if those influencers are people you know and trust? People like physicians. Pharma companies will routinely work with clinicians and go, can you talk about our drug for us because people respect you? Are the rules different if are you even acting as an influencer in that role, or are you just a scientist who happens to be having a scientific engagement with other doctors?
Right. So I think the FTC has done a lot with this. I think the FDA, for various reasons, has been more cautious about it. But the FTC's general view is, look, people hire experts to promote their products all the time, right? Because the experts are more credible. If that, so if you want the extra credibility of the expert, you take along with that, again, the risk that they're going to say stuff that you can't substantiate. But so usually the payment process is enough. And the fact that you don't put constraints on what they say is not an excuse. It's actually a reason that you screwed up by not putting constraint. Like, it is true that when you characterize something as like continuing education,
Right.
Courts are more reluctant to say that is pure advertising. But frankly, on Instagram, I think it's not very persuasive that it's pure education.
Very interesting. So what I hear you saying is that now do you, so many questions that pop out of that. What you're saying is, if it's Instagram, everyone can access it. It's hard to argue it's pure education, because it's, at that point, you're not necessarily even talking to other physicians. You kind of have to assume that any audience can catch it.
Right.
What happens if that same conversation is happening on LinkedIn? Is that still seen the same way?
That's a great question. And am I even aware of any enforcement issues? So I think it's quite similar. That is, and actually, to the extent that people expect people to be promoting themselves on LinkedIn, which I think is the more standard, that may actually heighten the need for disclosure, right? Because the baseline expectation is, I'm basically promoting myself, right? If it turns out that you're also like secretly promoting a particular company, then
Right.
The consumer really does need to know that, because it's a violation of the baseline expectations.
So what I hear you saying is, theoretically, it might be good enough to say on their LinkedIn profile to put up represented XYZ company as spokesperson, and that would be good enough, and they may even look good in their LinkedIn resume.
I mean, it really depends. So I will say, the FTC has also, like I said, has been, thinking about this a fair amount. And so what they say is, like, it'll only work if it's in the profile, if people will actually see the profile, depending on how, it's being portrayed. So, for example, on Instagram, right, something that is just in your profile won't actually necessarily show up on any given post,
Right.
unless you basically put it in your name, which you can, right?
Right.
I have to admit, I haven't used LinkedIn in years. So I would say, you just have to check how it displays. And in fact, you should check how it displays on mobile. And again, the FTC has sort of been pretty insistent that you have to look at how people are actually going to be accessing it. So will your disclosure be visible to them?
So how does that play out when the influencer is not necessarily a person? Does that change things? And what I'm thinking about is, does it just become speech at that point if you basically, instead of putting it onto, like, having person X say it, you put it onto Wikipedia? Do the rules change?
Yeah, so this is a super interesting question, and so not in the pharma context, but there's at least one case that says if you pay someone to change Wikipedia, then that is commercial speech as to you, right? So it wouldn't be Wikipedia's commercial speech, because they don't have a financial interest in it. They're not getting paid either way. But since it's commercial speech as to you, and so if you broke whatever rules apply to you, that can violate the law.
But you're saying, if you paid someone, do you mean as an agent or as an employee? Because a company has to work through someone by definition.
Right, that's true. So in the case I'm thinking about, I think it was actually an outside, like, promotion firm.
Okay.
So not quite a traditional ad agency, but not unlike one either. And certainly, if you told an employee to do it, it'd be your speech.
Interesting. So the idea is, if you control it, you own it, and you need to monitor it, which is really consistent with what the FDA has been saying as well, which is you need to monitor what's being said. At what point are you allowed to stop monitoring? Like, how, if you were talking to companies who are saying, we want to launch these multiple social media programs, One of the big questions that comes up is, at what point can you attribute comments made by third parties to yourself, and they are on your website? At what point do they become influencers for your company, even though
Right.
you never charge them to do that?
Right. And so the FDA has announced principles that
Mhm.
suggest that you're responsible even if you aren't paying them. I think that is something of a stretch. On the other hand, like if you start promoting comments on your own webpage, I
Right.
think the FDA is going to treat that like yours, right? But comments on Kim Kardashian's Instagram, unless they're clearly marked as coming from the company, I think that's I think a bridge too far, and I don't think the FTC or the FDA would think that you were responsible for those. However, the FDA has suggested that if people make a bunch of comments on social media, you should at least go correct them, right? And the very interesting thing for me is they actually made an exception for all the full information you usually need, right? If all you're doing is just correcting misinformation, you can just like tweet it. Like
Right. Right.
that's not right.
Do you believe that agencies need to amend the way they actually regulate now? And what I mean by that is, we've traditionally depended on a announcement or a letter from the agency going, "You did something wrong." In a
Mhm.
world like Instagram or a world like Twitter, where everything's so instantaneous, and the Kim Kardashian tweet was Instagram message was
Mhm.
14, 15 days earlier than when the actual message went out. It had already gone out to 15 million people. I'm making up the numbers. I have no idea if it's
Yeah,
15 million
yeah,
or not.
sure.
But the point being, should the agency have had a method to basically go, "Are you sure you want to say this?" And that comes up, and so it's not necessarily prohibitive,
Right.
but making you aware that there's a potential concern.
So I think there's really a staffing question, right?
Mm.
So the resources are limited, and whatever the rule about how fast the agency can react, there's a limit on how fast it will react to
Correct.
most things. So and uh, at the SEC, they seem to have a full-time team on Elon Musk. I don't think it's cost justified to do that for Kim Kardashian, right? I mean, one of the interesting things about making this a pretty public thing with Kardashian is it does serve as an educative effect. So really, in an imperfect world, it's really better to get a really attractive example so that people can understand that they do have obligations, and then go from there. Um, the faster mechanism question is really interesting because, of course, there are government programs all around the world that work with Instagram, Google, Twitter, and report stuff. So different country, but they tend to focus on things that are politically interesting to them, not on consumer protection. So you could have a team that was like the government web safety team,
Right.
and did more on that. But in general, governments have decided to invest more in political stuff.
Very, very interesting. We could keep going. We're already well past the time. This was incredible as always. Rebecca, thank you so much for coming on. Any
Thank you for having me.
A couple of things for people who are listening. What are the best ways for people to reach you?
So I'm at rtushnet on Twitter and at tushnet.blogspot.com. Not too many Tushnets in the world, so pretty easy to find.
Wonderful. And one last question. What would you like to ask the audience?
So I guess I'm actually interested in uh, to what extent pharma does see potential. Well, actually, okay. Here's my really stupid question. Are there people in pharma trying to think about how they can use NFTs to make more money? Because
Oh, yes.
everywhere else I go, I see people saying, "Okay, how can I get a piece of that?" And I was wondering, right? Speaking of Wild West, what would it be like to go from very highly regulated space? Is there a way to get into this unregulated for now space? But I also am, I think, more seriously interested in what are the possibilities for these sort of more informal lines of communication. Is there anything what that is healthy? Can we work on?
So I'll answer both questions for you. So the first question is, are NFTs being regulated? Like, is pharma interested in it? Absolutely. I actually have several interviews on exactly that. I'll try to send you a couple
All
links
right.
just so you can see them. The second more interesting question is, what informal methods? Yesterday's yes, well, technically this is a warning letter from, I think, yesterday, the day before, but it came out about 14 days ago. The point being, the 11th, Feb 11th. And the conversation was about a CEO of a pharma company who went out and basically had, and this is not a political statement, but this is more of a stylistic statement. President Trump used to talk in generalities and in senses of grandeur. And in the same way, this CEO went out and spoke about things like, wouldn't it be great if the results were like blah blah blah, and the FDA was not a happy camper about it. So, so the FDA kind of looked at what is effectively a YouTube video and was commenting on. I was talking to a friend of mine, and she went, "This reads like an infomercial, not like a scientist talking about his product." So I think the what people are forgetting, especially in pharma, is that just because the methods of communication have changed doesn't mean that the rules have changed. And I think that's the takeaway message. I do these interviews as like the one you and I are doing right now with CEOs decently often, and every time we do it, I hope and pray that their media team has had a conversation with them. Every once or twice, I have had to try to reframe the question so that they can give back some of the comments they're making, because they might be a little bit more expansive than they wanted them to. I'd say 99.9% of the time it's okay, but I remember one instance where I had to do that, and they caught it and they put it back. But that was interesting to me. So your point stands, and I think influencer marketing and influencer commentary is interesting, especially in the healthcare field, because I think, unlike with a Tesla, where your worst case scenario is that the stock goes up or down, or your car doesn't work, with health you can just die, and that's a lot worse. This was amazing as always. Thank you again so much
Well,
for
thank
coming on.
you. It was a great conversation.
We'll be in touch again.
All right.